Peter Dunn.
Mr Chairman, I take a call at this point. There have been some 10 speeches in this debate so far. I think I've been asked 3 specific questions, and there's one from the second reading that I also want to respond to. But before I do so, it's perhaps important just to place this debate in a wider context. A lot's been said about what may or may not happen with regard to the rules for eligibility and the way in which people might take out student loans in the future. The responsibility of this legislation, and my responsibility as the Minister of Revenue, rests with the administration of the student loan scheme, whatever shape or form it might be in. And as part of that portfolio, I've got to be mindful of a couple of facts. We have a student loan outstanding debt liability, call it what you like, of around $10 billion. We have somewhere in the order of 540,000 student loan borrowers with outstanding balances. We have around 40,000 students offshore, and when we sought to identify them and get their up-to-date details a couple of years ago, we managed to get just under half of those people actually back in contact with us. The point is, we have this massive debt, which speakers on both sides have acknowledged, that we need to manage. And what these changes are about, and some other changes that were contained in a discussion document released late last year, which will be the subject of legislation later this year, are about is making it easier for people to meet what we all regard as their repayment obligations. It's against that backdrop that I want to comment on the questions that have been raised so far. Carmel Sepuloni raised the question about the repayment mechanism for students in what we quaintly term the realm countries. Before I answer that, can I just comment on Moana Maki's point? I think she's absolutely right when she talks about the benefit for students in those countries of access to the student loan scheme. And one of the drivers for me in being keen to promote this was actually a visit to the Cooks a couple of years ago and talking to senior school students about their aspirations for their futures and about the practical difficulties they would face, not in getting access to New Zealand universities, but in funding their study when they came here. So that was a very important move. What happens, though, as Carmel Sepuloni asks, once they complete their studies and return to their country of origin, hopefully to make that economic and social contribution that this is all about? Well, Mr Speaker, I just draw her attention to the provisions of the bill. I don't have them right in front of me, it's a very long clause number, but in fact what students will be required to do is determine their income level, advise that to Inland Revenue, and then the process for getting their repayments on an annual basis will be put in place. This is a point I will return to in response to some of the other questions, but I should also just make the comment that the changes we are contemplating at the moment in terms of moving to an electronic base for repayment, so that the system actually becomes in time more like the way in which we conduct our banking operations today, will make it much easier for those students as well, because they will be able to access their account, their balances, and make their repayments as their circumstances fit. That will apply to all students, but it will be particularly beneficial to students in the realm countries. Let me come to the question of the grace period. I have to say there was no particular science to the choice of the 30-day period. We did think that, again, because the major beneficiaries of this change will be students who are overseas, that 15 days was probably a little tight in the circumstances. But with today's technologies and communications, even using the member's example of the deepest parts of Africa or somewhere, that 30 days was not an unreasonable choice. And again, I would say that once we bring in the next leg of this, which is in terms of the electronic basis for the system, I think that becomes quite a manageable operation. But obviously with all of these things, they are kept under constant review. Now, during the second reading debate, Chris Hipkins raised the question of the partners of diplomats and whether or not they are eligible for the extended provisions. This is actually a much more complicated question than first appears the case. We don't have within the student loans legislation a particular provision with regard to that category of person. What we do have is a requirement that a borrower or the partner of a borrower is eligible themselves if they are resident for tax purposes in New Zealand during that period. Now, the particular problem that arises for all people who are offshore is that definition of tax residence. And with respect to the specific question of the status of diplomats and their partners, this matter has been considered by Foreign Affairs, by Inland Revenue and by the Ministry of Education. And the conclusion that was reached, Mr Chairman, the conclusion that was reached was that there was actually an issue that was beyond the specific ambit of the student loans legislation to address. But I guess it's a matter that will be, again, between those agencies, kept under some form of review, and if there are issues that need to be addressed, then they will be picked up at that point. Mr Chairman, can I just simply conclude by going back to where I started and pointing out to the House that what we are doing here is making a much more effective management process for a very large investment by the New Zealand taxpayer. $10 billion, the vagaries of government accounting systems mean that that $10 billion is actually shown as an asset on the Crown's books. So it is incumbent upon the Crown to do what it can, A, to recover that funding, and B, to make it easier for those who are making repayments to do so. And what this legislation and legislation that I'm foreshadowing later in the year will be all about is achieving that objective.
Chris